and welcome to all the CA Inter students. I hope you're doing well and busy preparing for your May 22 exam. In this video, we are going to discuss each and every question from the RTP relevant for May 22 examination. In my previous video, I had discussed the amendments relevant for your attempt. In case you have missed that video, do click on the I button and you will be able to watch all the relevant amendments for your attempt. If you are a November 22 student and watching this video, then the amendments for May 22 apply to you also. So do check the video for the relevant amendments for May 22 as well as November 22 examination. If you're watching my video for the first time, I am CA Preeti Aggarwal and I make videos specially for you. Do subscribe to your channel, Theory Masters Learning, and hit the bell icon so that you get notifications for all the important videos. Also visit my website 𝗟𝗲𝗵𝗲𝗀𝗇.com and check out the new chart book that we have launched for CA Inter exam. So let us discuss the MCQs. This time they have given only one case scenario based MCQ. Otherwise they normally give two samples, but here I can see only one. Not an issue. Let us discuss that. Students, this time I want you to first attempt the questions on your own. Normally what happens is we take a shortcut. If there is someone who is already discussing the RTP, we don't apply our mind. What we do is we just watch the video and side by side we go through the RTP questions. But I don't think that is the right way to study, because in the main exam we are not going to be there to help you. So my advice to you is that first you solve these questions on your own. Like, you need not solve the entire RTP today itself. Solve only the MCQs. Then tomorrow solve the first 5 questions, and the day after that solve 5 questions, and watch the video only after you attempt the question on your own. If you want, you can pause the video anytime you want. So right now, I think if you are done with your revision, you should pause the video, try to attempt the case scenario MCQ and other multiple choice questions. After you're done with that, then you correct your answers. You go through the explanation along with me. Yes, can we do that this time? So we are going to pause in between. I will give you time to go through these questions. Sometimes I will also ask you to pause the video and write the pointers so that you know how to frame the answer, and then we will check as to what is the expectation of ICAI. So there will be a lot of writing practice in this video itself. We always complain, as CA students, ma'am, we don't have time, there was not enough writing practice, that is why I scored less. So why don't we take this opportunity and write and practice few questions while watching this video? So quickly go and get a notebook and pen. If you have a copy of the RTP with you, just grab that copy, sit, only then you continue watching this video. All right, now I'm giving you 5 minutes. Just pause this video, take 5 minutes, go through the question. Even if you're not confident, even if you are not confident, even if you have not revised, at least try to attempt. You'll know your mistakes, and if the answer is correct, I know you will feel very happy. Yes, so just pause the video for 5 minutes, solve the case scenario and MCQ questions, and then we will discuss. Pause now. Okay, I'm assuming you did the needful. So let us read, and I don't think we need to read it again, but yes, while reading, we should know how to identify the keywords. So in order to teach you that, I am going to read the question along with you, but we'll just quickly go through it, all right? Perfect Tires and Rubbers is a listed entity engaged in the business of manufacturing tires and tubes for light and heavy commercial vehicles. During the financial year 1920, the company has declared interim dividend of 5% on the equity shares. So this information is important for me. One more important information is the year to which this question relates. So this, the question, the scenario is related to the year 2020. Okay, so that is also important, and later you will realize why I said that. So the company has declared interim dividend on equity shares in the board meeting held on 17th October 2019 out of the profits earned during the first quarter. Interim dividend is recommended and declared by the board of directors. They recommended the second interim dividend at 5% on 25th April 2020. So these two facts are important for us. The board of directors of the company approved the financial results for the financial year 1920 in its meeting held on 5th August. So approval of the financial year, okay, on 5th of August. So the board of directors approved the financials on 5th of August and recommended, because that is done in the board meeting, recommendation of the final dividend at 15%, including the interim dividends paid earlier. The general meeting of the company, of the shareholders, that is, they are talking about the annual general meeting, was convened on 31st August 2020. So that date is relevant for me. That is why I have mentioned it. See, I have mentioned it over here. These are small notes which I take, I write while reading the question. You need not write this in your question paper, but you can always do this on the last page of your answer sheet. That can be used as a rough page. So just go on writing these facts, because this will save a lot of time in exam. You need not read the question again. So they declared final dividend, date of declaration of dividend is 31st of August. Many a times we also recommend the students to go through the questions first. But sometimes what happens is, no, they don't understand the questions and they start panicking. So you decide what should be your approach. First read the questions, then read the passage, or you want to do it the other way. Final dividend of 15%, the general meeting on 31st of August, shareholders demanded that since the interim dividend at the rate of 10% was declared by the company, so the final dividend should not be less than 20%, including the interim dividends. The company secretary emphasized that final dividend cannot exceed what the board of directors have recommended in their board meeting. Some of the shareholders boycotted, they left the meeting and moved out of the meeting hall in protest. However, agenda for declaration of dividend was passed unanimously by the rest of the shareholders present in the meeting hall, fulfilling the requirement of quorum. It means that these members were present when the meeting started and during the meeting. Okay, so I have made few other notes. Board's recommendation 15%, but the shareholders are demanding 20%. The company is holding the meeting on 31st of August. That is the date of declaration of dividend. And we have discussed, yes, you may have watched my revision lectures for C-Enter. We are also, yes, coming up with new revision lectures for May 22 students. And it will revolve around beautiful, colorful charts. So do click on the subscribe button and the bell icon so that you get notification for the revision videos. Yes, we are coming up with revision videos, and I'm planning videos in Hindi as well as English. So we will do it in two languages, separate videos for students who are comfortable in English only, and separate videos for students who demand, nahi ma'am, we want it in Hindi only. Okay, so AGM on 31st of August plus 30 days, because we had studied that dividend when declared should be paid, or at least warrants should be dispatched within 30 days of declaration. So dividend should be paid and warrants should be dispatched within 30 days. It is okay if the warrants reach after 30 days, but at least it should be dispatched. So that is 30 days, and there is more information. So I have calculated when do these 30 days get over. So if the date of declaration of dividend is 31st August, 30 days जब आप calculate करोगे, you will come to 30th of September. We are calculating in days, remember. 30th September 2020. इसमें हमने और भी पढ़ा है that if the dividend is not paid, it is not claimed within those 30 days, then the dividend, whatever is the unpaid dividend, should be transferred to the unpaid or unclaimed unpaid or unclaimed dividend should be transferred to the unpaid dividend account. वही लिखा है मैंने वहां पर. So 7 days जब हम calculate करेंगे, so it means 1st October, because there are 30 days in September. So 1st, 2nd, 3rd, 4th, 5th and 6th and 7th October. These dates are very important for us. अच्छा, अब आप बोलोगे कि मैम ये तो आपको पहले से ही पता था, आपने इसीलिए नोट्स बनाए. नहीं, you should anticipate that if this is the data provided to me, next they will definitely ask me that it should be paid within 30 days. If it is not paid within 30 days, I need to transfer the amount to unpaid dividend account within 7 days. These are time saving techniques. This will help you to save a lot of time when you read the question. Okay, now they have provided more information. The company transferred the amount on 15th of October. देखो, When have they transferred? 15th of October. And when was it to be transferred? 7th October. There is a delay. They will be liable to pay interest at the rate of 12% per annum. Because see, when your concepts are clear, your mind should start, anticipating. अच्छा ये नहीं तो फिर क्या, ये नहीं तो फिर क्या. You should know what is the next information. Automatically आपके mind में आना चाहिए. Guys, if you want कि आपके concepts thorough होने चाहिए, if you want कि नहीं ये जो data है 12% होना चाहिए, 30 days में होना चाहिए, ये limits मुझे याद करने हैं. So the best method is that, you should have a chart in front of you. Keep reading it every day. Ma'am, कहाँ time है ये सब के लिए? So for that, we have recently launched a chart book for all the CA inter students who are planning to attempt in either May or November 22. Amendment सब included है वहाँ पर. I'm leaving a link of the chart book in the description box. Do check the chart book on my website 𝗟𝗲masterslearning.com. ठीक है. तो वो जो डेट्स हैं, वो जो लिमिट्स हैं, वो जो पेनल्टीज हैं, ये सब हमें याद रखने के लिए वी नीड चार्ट्स रेडीमेड, ताकि हमारा टाइम से वो वी नीड नॉट मेक नोट्स एंड वी कैन इमीजिएटली रीड दोज चार्ट्स. चलो, then the details is of dividend is given over here. See students, the question is for the financial year 1920. तो इसीलिए हमारे लिए जो डेटा इंपॉर्टेंट है वो है 2013 वाला डिविडेंड. See, because for the dividends which are transferred in the year 2020, 2019, 18, 17, 7 years is not over. Do you remember that provision? It will lie in the unpaid dividend account and after 7 years it will be transferred to IEPF. So what is relevant for us is 2013 data, because now 7 years are over in 2020. That amount will be transferred to the unpaid dividend account. So whatever data is given to you, try to, before you read the question, try to analyze that data. Then S, one of the investors is holding 1,000 shares in the physical form, came to know that the company had declared dividend, but it has not been paid to him. This happened due to the fact that the company was not having his current address. So he approached the company and he demanded the dividend amount. The company, after being satisfied, paid the dividend. However, for financial year 2012-13, the company informed that the amount had been transferred to IEPF, cannot be taken back now. He's agreed and he goes to the officials to take legal action. Unfortunately, this data has not been asked in question form at all. So let us go through the questions to understand. सबसे पहला question है, when the shareholders demanded for increase in the rate of dividend, but since the shareholders cannot increase the rate of dividend that the board of directors have recommended, तो board ने जितना recommend किया है उससे कम या उतना आप declare कर सकते हो, ज़्यादा नहीं. Some of them walked out. What shall be the consequence of this? So if even after boycott the quorum is present all the time, ये बहुत important है, quorum should be present at all the time during the meeting. ऐसा नहीं होना चाहिए कि starting में quorum था फिर सब चले गए and ultimately only 2 people are passing all the resolutions. ऐसा नहीं होना चाहिए. The minimum जो quorum requirement है that should be present throughout the meeting. So during the course of the general meeting, they have approved with the majority the rate recommended by the board, then it will be treated as approved. So जो quorum था उन्होंने approve किया even after boycott. Members present at the beginning shall remain present all the time during the general meeting to approve the agenda, else it will be treated as nullified. The approval of dividend is an ordinary business, yes. So if some of the members have boycotted, it will have no effect even if the quorum is not present. या फिर recommendation of the board relating to the rate shall stand withdrawn. आपको बेस्ट ऑप्शन चूज करना है. सी ए एंड बी ऑलमोस्ट सिमिलर ही लगेगा आपको, बट द ए ऑप्शन इज द बेस्ट ऑप्शन. तो अगर आपने ये सिलेक्ट किया है तो इसका मतलब है कि आपने जो सिलेक्ट किया है वो बहुत ही सही है. Even after boycott, if the quorum is present at all times during the meeting, they have approved with majority, because dividend declare करने के लिए you need to pass just an ordinary resolution. It's an ordinary business. Pass an ordinary resolution. Ordinary के लिए you need approval of majority. Then the rate of the board will be treated as approved. तो ये जो option है, it is best of the 4 options. तो आप A option select करेंगे. Then at which date the unpaid dividend not claimed by shareholders shall be transferred to a separate bank account. तो 30 days तक आपको पेमेंट करनी है. नहीं करोगे तो अगले 7 दिन में. सी आई एम ऑलरेडी रेडी विद द आंसर, बिकॉज वाइल रीडिंग द क्वेश्चन आई हैड एंटिसिपेटेड कि हाँ ये डेटा अवेलेबल है, तो ये डेट्स मेरे पास रेडी होने चाहिए. तो 31st को मीटिंग थी. 30 डेज के अंदर अंदर आपको डिविडेंड पे करना है, या वारंट्स तो इशू करने ही है. उसके बाद अनपेड या अनक्लेम डिविडेंड जो है दैट विल बी ट्रांसफर टू द अनपेड डिविडेंड अकाउंट विद इन द नेक्स्ट 7 days. तो 30th सितंबर के बाद 7 दिन अगर आप देखोगे, इट कम्स टू 7th of October. सो दैट इज द आंसर. आई एम ऑलरेडी रेडी विद द आंसर. लेटेस्ट इट शुड बी गिवन बाय 7th October. ठीक है, 7 days फ्रॉम द एक्सपायरी ऑफ द सेड 30 days. The company transferred the amount of unpaid dividend on 15th October. उन्होंने लेट किया. ये तो डेटा था ना, मैंने इधर हाईलाइट भी किया था. Here it is. When I read that data, I knew that there is going to be a question on this. So I was prepared. Yes, there is a delay. So we will have to pay interest at the rate of 12% on that amount which has not been transferred to the unpaid dividend account. So students, if you have selected these options, you should be very proud of yourself कि आपको correct answers आए हैं. Very good. In the given case, when and how much amount the company shall transfer to the IEPF. मैंने बताया था आपको 2020 का क्वेश्चन है. So 7 years will get over only for the last amount, that is 8th July 2013. That is when the amount was transferred to the unpaid dividend account. It will remain there for 7 years. So this is the amount that will be now transferred to the IEPF. Okay, so this is the amount that will be transferred to IEPF. 7 years after 8th July 2013. So 7.25 lakhs will be transferred. A very simple question. Actually facts दिए थे and the questions that were asked उसमें बहुत ज़्यादा link था नहीं. I thought maybe the last part पे they will ask questions, but they didn't do that. Second, now I hope you have solved these questions. Yes. Amber Limited is a manufacturer of glassware. Its paid up share capital is divided into 2 lakh. Yes, it is 2 lakh shares of 100 each. The company is maintaining the register of members as per the provisions of the Companies Act. The company wanted to close the register of members for declaring dividend. So it may do so by giving minimum. Answer is 7 days notice. They can close by giving 7 days notice. This is given in section 91. So see, for your reference, I have mentioned the provisions of section 91, power to close register of member or debenture holders. Students, if due to any reason you have not studied these provisions, this is a good way to, go through the section, go through the provisions. So this is the advantage of solving MTP and RTP. A company may close the register for any period or periods not exceeding aggregate of 45 days in each year, not exceeding 30 days at one time, subject to giving of previous notice of at least 7 days or any lesser amount as specified by SEBI. So as of now, it is 7 days only. The correct answer over here is 7 days. If you want to download this document, you feel that, ma'am, please give us this document ready-made, you can download this document from the e-note section of my website, theorymasterslearning.com. So just go to the e-note section. Link is in the description box. You can download this document with all my handwritten notes. Next is dash interpretation concerns itself with what the law says and what the law means. So the grammatical interpretation, which is as the text demands, जो लिखा है उसको वैसे का वैसे ही समझो, that concerns with what the law says, and the logical interpretation is what it actually means. Yes, so that is the correct answer, option A. Next, we have Arvind lends money to Mamta against the security of jewelry deposited by Mamta with Arvind. So I have a pictorial representation of that. Arvind gave loan to Mamta. Mamta gave her jewelry. Arvind then pledged that jewelry. He gave the jewelry to his friend Vinayak, who had a safe locker at his home. Who is the pawner in the given case? Who is the pawner? Now in this case, Arvind has given loan to Mamta and Mamta has given jewelry as security. As security, it means that Mamta in this case is the pawner. Ma'am, why have they given us the fact that Arvind gave his jewelry to Vinayak to keep at home? That is bailment. that is bailment. You have given it to Vinayak for safekeeping, that is bailment. If anything is given for safekeeping, transportation, that is bailment. But anything given as security for due performance of contract, for payment of debt, that is pledge. So the pawner is Mamta in this case. If you have selected Mamta, then your answer is correct. Raman, the original allottee of 2000 equity shares in ABC Limited, has transferred the same to Ruchi. The instrument of transfer dated 21st August, duly stamped and signed, was handed over to Ruchi. Wait, represent this properly. So Raman has transferred shares to Ruchi, 2000 shares. The instrument of transfer was delivered, was dated 21st of August. It was duly stamped and signed. Advise Ruchi regarding the latest date by which the instrument along with the shares must be delivered to the company. So SH4, the instrument of transfer, must be delivered to the company within 60 days of execution of transfer. So 60 days from the date of execution comes to 20th October. कैसे calculate किया है मैंने? 10 days of August, 10 balance days. तो जो from date है 21st of August, वो नहीं लेंगे हम. Balance 10 days, balance 30 days of September, balance 20 days of October. So ऐसे करके 60 days हो गए. So 20th October, answer is 20th October, option C. If you have selected 20th October, very good, your answer is correct. तो ये थी उसकी working. Again, I repeat, I have uploaded this document in the e-note section of my website. So if you want, you can download this document containing my handwritten notes. चलो, next let us discuss the descriptive questions. यहाँ पे बहुत थोड़े से questions दिए हैं इस बार, काफ़ी manageable है, easy है, फटाफट ये भी डिस्कस कर लेते हैं. लेकिन मेरा इस बार का मेथड सेम ही रहेगा. फर्स्ट ट्राई टू अटेम्प्ट दिस ऑन योर ओन. डोंट रिलाई ऑन रेडीमेड सॉल्यूशंस. ट्राई टू सॉल्व दिस ऑन योर ओन, then discuss it with me. So yes, please pause the video now, go through the first 2 or 3 questions, and then you can check the answer with me. So let us discuss the answer to this question. It's a new question, okay, because the definition of listed company was very recently amended and there was no question on that concept. So this is a new question. This kind of question has never been asked in the exam. It is a combination of 2 concepts. So I think this is very, very important for exam. And if you see the latest trends, there are many questions which they have asked from RTP, MTP, not of that year, but of the previous years also. So this is a new question. You should study it one day before the exam. I hope you have read the question, because that is the whole aim of this discussion. Now I will just jump to the answer directly. Okay, in this question, first they have asked you what is a listed company. Then the second part of the question is what is the relationship between these companies. That is why these 2 datas are given to you. So the securities issued will help you to identify whether it is a listed company or not, and the remark section, that will help you to identify the relation between these companies. Now K Limited, I Limited and S Private Limited, they have securities issued like non-convertible redeemable preference shares, non-convertible debt securities, listed non-convertible debt securities by a private company. You have to decide whether these companies will be considered as listed company or not. Answer is very simple, students. There is no complication in this question. I was very surprised because I was expecting some twist, something, but it is just a simple application of the definition. So how will you start the answer? You will start your answer by writing the definition. So step 1 is write the definition, because the question is based on the definition. You need not write the definition for every answer. But if the question is directly based on the definition, then yes, you have to write the definition. Definition along with section number, yes. So important for exam, that is why you need to memorize the section also. Section 2, clause 52. It defines a listed company as a company which has securities listed on the recognized stock exchange. So if you are a company and you have listed the securities on the stock exchange, you are a listed company. There is a proviso, okay, such class of companies which have listed or they intend to list such class of securities. See the wordings, they are so wonderful. Such class of companies. So they will specify the class of companies and they will specify the class of securities, if issued in consultation with SEBI, shall not be considered as listed company. So the Companies Act will specify the class of companies. The Companies Act will specify the class of such class of securities issued by those companies which will not be considered as listed companies. Okay, so if you are a company and you have issued such class of securities, then you will not be considered as a listed company. Now, what is the first step that you need to do? The first step is to identify whether it is a private or a public company. Why? Why have I written this? Because if you read the definition properly, students, it revolves around the type of company, one, and then the security issued by that company. If you are a public company, your shares, equity shares, are not listed on a recognized stock exchange. This is very important for me. I am a public company. My shares are not listed. Okay, equity shares, they are not listed on the recognized stock exchange. But, or however, non-convertible debt securities issued on private placement basis in terms of SEBI regulations, then yes, even though, sorry, just a minute, this is also important. So I am a public company, but my equity shares are not listed. However, I have listed my non-convertible debt securities which were issued on private placement basis in terms of SEBI regulation, then I will not be considered as a listed company. Okay, even though these non-convertible debt securities are listed, I will still not be considered. Now, why have these exclusions? Why are these exemptions included here? See, when you list your securities, there is a lot of compliance involved. There's a lot of paperwork. There are many things that you need to comply with. Why burden these companies? Anyways, their equity shares are not listed. Why burden them with compliances? So for the ease of doing business, a lot of exemptions were given to these kind of companies. Then we have public company which has issued non-convertible redeemable preference shares issued on private placement basis in terms of SEBI regulations. If it is not possible for you to remember the SEBI regulations, then that's perfectly fine. Just write as per SEBI regulations. All right. Suppose you are a public company and if you have issued both non-convertible debt securities as well as non-convertible redeemable preference shares, then you are not considered as a listed company. You are a private company. Okay, now a private company cannot list the equity shares. That is why it is not given only. That criteria is not specified. But you have listed your non-convertible debt securities on private placement issued in terms of SEBI regulations. So even if you're a private company and you have listed your non-convertible debt securities, don't worry, you will not be considered as a listed company. You are a public company. Okay, again, public company. You have not listed, so I will highlight the word not. You have not listed equity shares on a recognized stock exchange, but your equity shares are listed on a stock exchange in a jurisdiction, in some foreign jurisdiction, as specified in subsection 3 of section 23 of the Act. Even then, you are not considered as a listed company. So your equity is not listed on a recognized stock exchange in India, but your equity is listed on a recognized permissible stock exchange in some foreign jurisdiction. Even then, for us, you are not considered as a listed company. Now let us see the application. K Limited. Okay, K Limited has equity shares which are not listed, but they have issued listed non-convertible redeemable preference shares issued on private placement basis by following the SEBI regulations. See why these words are important for us. Why have I highlighted those words? Because in the answer you will have to mention that the securities are one, non-convertible redeemable preference shares. They are issued on private placement basis and after following the SEBI guidelines. So I'll just change the color for you. They are followed using the by following the SEBI regulations. These are three keywords. They have to be present in your answer. So equity shares not listed. redeemable, non-convertible preference shares issued on private placement basis by following SEBI regulations. It falls under an exception. You will not be considered as a listed company. So you will first identify the type of company, whether you are private or public, then you will identify the type of security. I Limited, equity shares not listed. They have, yes, it's a public company, but they have issued non-convertible debt securities on private placement basis by following the SEBI regulation. Now you understood the keywords. This will help you frame the answer. This falls under an exception. It's not considered as a listed company. You are a private company. You have issued issued listed non-convertible debt securities on private placement. Yes, I am a private company. Non-convertible debt securities on private placement following the SEBI regulation. You are covered under an exception. It's not considered as a listed company. So very simple answer. You can write it in this manner, tabular form, but if in the exam like the same question is asked and you have written in paragraph form, give the heading K Limited, write the paragraph, I think you need not worry. That is also acceptable. For the second part, now they want you to find the relation. Let's go back to the question. Okay, let me go to the question. These are the remarks and let's see how we can use them. K Limited has the power to appoint 2/3 of the directors in I Limited. So I have written it. See the left part of the screen. K Limited can appoint 2/3 means majority of the directors of I Limited. This is an application of holding and subsidiary concept, no? I am a holding company if I can appoint or remove all or majority directors of your company. So K is the holding company of I Limited, or in other words, I is a subsidiary of K Limited. I Limited holds 60% of the voting power in S Private Limited. Okay. So if you own more than half of the voting power, then yes, you are the holding. That company is your subsidiary. So I is the holding company for S. S is the subsidiary. And from this you should also know कि आपने एक कॉन्सेप्ट पढ़ा होगा कि इनडायरेक्टली S1 is the subsidiary of H. जिन्होंने हमारे पास एनरोलमेंट की, जिनके पास मेरे नोट्स हैं, yes, the ones who are studying from my notes and the videos, HSS1 पढ़ा था ना हमने. तो K Limited is the holding, its subsidiary I has another subsidiary S. So indirectly S is also the subsidiary of K Limited. S Limited holds 52% equity shares in P Limited as an investment on behalf of another company, just in the capacity of a trustee. Is there a holding subsidiary relation between S and P? That is what you need to decide. So think for a minute, then we will discuss. So are you ready with the answer? Yes. Now to establish the relation, we need to first write theory, no? Ma'am, this is such a lengthy question. Will this be asked in the exam? It can be. Now you are finding it lengthy because we are discussing it in detail. And yes, the solution is quite lengthy. And if this question is asked in the exam, it will be asked for minimum 6 to 7 marks. Now you need to first explain the definition of, write the definition of holding company. I am holding if you are my subsidiary. Then you also need to write the definition of subsidiary. I am a subsidiary if you can control the composition of the board. How is the composition controlled? If you can appoint or remove all or majority directors, then you are my holding. If you own more than 1/2, that is 50%, more than 50% of the total voting power, either on your own, H owns 60% of S, H plus subsidiary owns 70% of S1, then S1 is the subsidiary of H. So yes, you can hold it either on your own or together with one or more subsidiaries. Layers cannot exceed 2. Company H owns 60% in S, S owns 70% in S1. So indirectly, S1 is the subsidiary of H. See, they have written everything over here. This deep part is important. The shares held by a company or the power exercisable by it in another company in just a fiduciary capacity, like you are holding shares not as the owner but as a trustee. Fiduciary relation means a relation of trust and confidence. So you are acting as a trustee. You are not the owner. There is no question of holding subsidiary relation. So over here, between K and I, yes, you can control, you can appoint or remove more than half of the board of directors. So 2/3, yes, you are a holding company. That company is your subsidiary. If you read the wordings, no students, it is very confusing. लेकिन इसको हमने simplify किया है. See, I is your subsidiary. इसका मतलब है that K is the holding. Over here, I and S में क्या relation है? S is the subsidiary या फिर I is the holding. Relation between K and S क्या है? Because S1, see, I have written the relation. Because S is the subsidiary of I is the subsidiary of K, indirectly S is also the subsidiary of K. तो वो relation लिखा है. This is all theory. Okay. What if you are holding the shares in a capacity of a trustee? Fiduciary capacity में हो तो holding subsidiary का relation आता ही नहीं है. There is no holding subsidiary relation. It is just held, the shares are held in just fiduciary capacity. Next question, interesting question. Again, yes, I think it's a new question. So can be asked in the exam. These are very good questions. This time the RTP has good questions. Abhiyogik, having 1,000 members with paid up capital of 1 crore, decided to hold the annual general meeting on 21st August. Date, important, AGM, 21st August. They received a notice on 2nd July from 60 members holding paid up capital of 5 lakhs. Important data. So let's highlight the important data. AGM is on 21st August. We receive a notice on 2nd July from 60 members. How much do they hold? 7 lakhs in aggregate. For a resolution to be passed at the AGM for appointing Vaidya and Company as auditor instead of the existing auditor, 𝗟𝗵𝗿 and Company, which was originally appointed for 5 years, but they have completed only 4 years term. It means you are planning to appoint another auditor in place of the current auditor before the expiry of his term. Yes. So a special notice is required. A special notice is required if you want to appoint another auditor before the expiry of the term of your existing auditor. Special notice is required. So a notice was sent by the company to 𝗟𝗵𝗿, which gave the resolution. Okay, so we have received a notice. Special notice is required because you want to appoint another auditor in place of the existing auditor, or you have said expressly that you can appoint any other person, not him. Special notice is required. Such notice was sent by the company to the current auditor, which gave its representation in writing. Yes, he has the right to be heard. He has a right to give representation. Why should he not be removed? क्यों नहीं निकालना चाहिए? वो बोलने का मौका मिलना चाहिए उसे. Representation लिख के देगा कि ये reasons है कि मुझे नहीं निकालना चाहिए. So he has given a representation in writing. But it was received too late. That is only 3 days. अभी 3 days में how will we send it to the members? Na? So in this case, in the context of the aforesaid facts, please answer the following questions. Whether the said notice was given by adequate number of members within the prescribed time. Special notice. उसके provisions थे ना? मैं क्यों बताऊं? You have to think about the answer. Ready-made is not going to help you in the exam. So what is the answer? Yes, shareholders holding at least 1% of the voting power or 5 lakhs in aggregate, they can give notice. Whether the company was bound to send to its members such representation made. No, it was received too late. We can't send it to member. तो क्या करेंगे फिर? Then we will give an opportunity for the auditor to orally give his representation, and if it is in writing and we could not send it, so we will he can ask that no, I will orally talk about it, but you read my representation. So that is optional. It depends on the auditor. If he wants, we can read the representation and he can also orally add to it Plus this representation, because it was not sent to members, a copy will also be sent to ROC. So there are many technical points over here, students. You have to be very careful when you write the answer. So what is written in the solution? See, as per section 140 subsection 4 of the Act. Now section 140 subsection 4, appointing an auditor other than the retiring auditor. Resolution for appointment of an auditor other than the retiring requires special notice. Okay. As per section 115 read with rule 23, 115 important for exam. Where by any provision contained in the Act or articles, special notice is required for passing a resolution. Now, special notice is required when you are removing an auditor before expiry of his term, like in this case. So if you feel, ma'am, the wordings are very confusing, can we write in our own words? Yes. So how will you write? As per section 140 subsection 4, resolution for appointing of auditor other than the retiring auditor is requires special notice. Special notice is required if you want to remove an auditor before the expiry of a term and appoint someone else in his place. So special notice is required. Then special notice will be given by such number of members holding not less than 1% of the total voting power or holding shares on which aggregate of at least 5 lakhs has been paid up. So this is the theory which you need to mention. Few points you can write in your own words. Other than that, the limits have to be mentioned. They have to be written as given in the Act. Now the notice, the special notice should be received not earlier than 3 months. You can't give 6 months notice. 6 महीने पहले ही आपने notice दे दिया कि इसका term खत्म होने वाला है, appoint someone else. नहीं, 3 महीने पहले, meeting के 3 महीने पहले ही देना, but at least 14 days before the meeting. Okay? So don't give before 3 months. 3 महीने पहले notice मत देना, लेकिन at least 14 days before the meeting notice मिलना चाहिए. The exclusive of the day on which the notice is given and the date of meeting, वो exclude करके जो clear days है वो at least 14 days before the meeting होना चाहिए. So now we come to the analysis part. Here the company is having 1000 members, paid up capital is 1 crore. 60 members ने दिया and they hold aggregate 7 lakhs. ठीक है, limit is satisfied. AGM was to be held on 21st August. At least 14 days पहले तो notice आना चाहिए ना. It means that you should receive the notice before 7th August. They have given on 2nd July. It's within the prescribed limit. After showing these calculations, we will then write, it can be said that the notice was made by adequate number of members and within the prescribed time. Yes. So in this case, everything is properly satisfied. There is another sub part to this question, sub question 2. Whether the company was bound to send the representation made by the auditor. If it was not sent, then what is the responsibility of the company? See, it was received too late. 3 दिन पहले ही मिला, तो कैसे भेजेंगे ना? तो देखो यहाँ पर मैंने एक चार्ट बनाया है. Members will give special notice to the company that we want to appoint someone else in his place. The company will send that notice to the retiring auditor कि देखो उन्होंने बोला है they don't want to continue with you. Retiring auditor will send a representation in writing. He may want कि भाई नहीं, ये representation तुम पढ़ो. The company will then forward the representation to the members. He wants them to read. तुम पढ़ो ये, तो representation will be forwarded to the members. But what if हम तो टाइम पे दे ही नहीं पाया, बहुत लेट मिला, but or maybe due to the fault of the company you could not send it to members. तो लॉ बोलता है कि 3 चीजें इंपॉर्टेंट है. The auditor has a right to be heard orally. भाई चलो बताओ क्यों निकालना नहीं चाहिए तुम्हें. And he also has the right to have the representation read in the annual general meeting because it was not sent, no? You can't tell, company ये नहीं बोल सकते, अरे तेरे को बोलने की राइट दे रहे हैं ना, why do you want us to read the representation? नहीं, ऑडिटर के ऊपर डिपेंड करता है. He may want the company to read also. And a copy will be sent to ROC because it was not read, sorry, it was not, that representation was not sent to the members. Now, in this case, where a notice is given to appoint any other auditor other than the retiring auditor will give representation in writing, not exceeding a reasonable length, and he will request, please send this to the members. So we will give a notice is given to the company. Then the notice will be given to the members कि भाई देखो तुमने स्पेशल नोटिस दिया था, उसने representation भेजी है, and a copy will be sent to any member who is entitled to receive the notice. But here, because it was received late, or maybe it was the fault of the company that it was not sent, then if it is received late, you are not bound to send it to member. Instead, you can read the representation. If a copy was not sent because either it was received late or maybe because of some company's fault, the auditor may, without prejudice to his right to be heard orally, इसका क्या मतलब है? उसके पास राइट है टू बी हर्ड ओरली, वो आप ले नहीं सकते. ये नहीं बोल सकते अरे भाई तेरा रिप्रेजेंटेशन पढ़ के सुना रहे हैं ना, तुझे क्यों बोलना है. वो तो राइट है. ऑडिटर मे रिक्वायर्ड, आई हैव हाईलाइटेड द वर्ड मे बिकॉज ये कंपलसरी नहीं है. वो बोल सकता है कि मैं बोल रहा हूँ, रीड मत करो. So he may require that the representation be read out at the meeting, and भाई इसकी कॉपी आरओसी को भी भेजो, तुमने मेंबर्स को टाइम पे नहीं दी ना. So 3 rights to be noted. 1, he has the right to be heard orally. Second, he has the right to make his representation oral. He has a right to request the company to read his representation, and he shall file the representation with ROC. So students, I think it's a very it's a properly drafted question. बहुत ही अच्छी तरह से उन्होंने क्वेश्चन ड्राफ्ट किया है और इसमें आप काफ़ी कुछ लिख सकते हो. अगेन इफ दिस क्वेश्चन इज आस्क्ड, आई थिंक वेटेज विल बी फॉर 6 marks बिकॉज देयर इज अ लॉट ऑफ कंटेंट टू बी रिटन. स्टूडेंट्स, इफ यू फील कि मैम नोट्स हमारे अच्छे नहीं हैं और यू आर रीडिंग फ्रॉम द मॉड्यूल, बहुत बार स्टूडेंट्स ऐसे होते हैं दे रीड फ्रॉम द मॉड्यूल, दे आर नॉट एबल टू अंडरस्टैंड द लैंग्वेज. वी हैव अ मेन लॉ बुक फॉर योर रेफरेंस. यू कैन विजिट माई वेबसाइट theorymasterslearning.com और वहाँ पर बहुत सारा कंटेंट आपको मिल जाएगा. बुक फॉर कॉर्पोरेट एंड अदर लॉज, कंपाइलर है जिसमें सारे पास्ट एग्जाम, स्टडी मटेरियल, आरटीपी एमटीपी क्वेश्चंस है, यूनिट वाइज अरेंज है, ये सब भी इंक्लूडेड है. वी हैव एमसीक्यू प्रैक्टिस पेपर्स, लक्ष्य एमसीक्यू ऑनलाइन प्रैक्टिस पेपर्स टू हेल्प यू टू गेट गुड प्रैक्टिस. वी हैव अराउंड मोर देन 300 क्वेश्चंस जहाँ पर आपको एमसीक्यू की क्विज होगी एंड यू विल गेट टू प्रैक्टिस मोर देन 300 क्वेश्चंस. Chart book for last minute easy revision. So there is a lot of content, so do visit my website theorymasterslearning.com. चलो अब आगे बढ़ते हैं. मेरा फर्ज है कि मैं आपको बताऊं कि अगर आपको मुश्किल आ रही है, if you are facing any difficulty, we have content, we have a lot of material available for you. Please take advantage of that material. My aim is that you should score excellent marks in this subject. Third question. Vrinda Limited is a company manufacturing orange and strawberry candies for kids. Now the company wants to expand the business and start manufacturing of 10 more types of candies. Okay. The company has raised 1 crore through the issue of non-convertible debentures, not constituting a charge on the assets of the company. This shows, देखो immediately analysis चालू हो जाना चाहिए आपके mind में. This shows that the debentures are unsecured. Okay, it is unsecured. All right, the company has raised through non-convertible debentures, not constituting a charge. These are unsecured, listed on the recognized stock exchange. तो हमारे लिए keywords यहाँ पर होंगे that it is unsecured. Let me write not constituting a charge on the assets, and it is listed on the recognized stock exchange. Will this be considered as deposit? Clear, clean question है. 2 marks का ही question आएगा ये. या फिर mostly मेरे हिसाब से this will come in MCQ. That is my estimate. No, it is not deposit. Any amount raised by issue of non-convertible debentures not constituting a charge on the assets of the company listed on the recognized stock exchange will not be considered as deposit. Normally ना students, ये case based question में अगर आता भी है ना, तो you have to write more content. ये तो बहुत कम लिखा है उन्होंने. You will have to write the definition of deposit. Then you will have to write whether this is included or excluded in the deposit definition. Then write the conclusion. So maybe 1 or 2 points you can add by defining what is a deposit. Don't write everything what is not included in deposit. It's a long list. वो लिखने की जरूरत नहीं है. Next, let us read the fourth question. So the first question is actually a theory question. The board of directors of Plum Limited proposes to issue a prospectus inviting offers from the public. Okay, yes. State the reports which shall be included in the prospectus. So very rarely they ask just specifically what are the reports to be included. Generally they ask what are the matters to be included in the prospectus. So this is concentrating on just the reports. So section 26, it's a theory question. Section 26, it lists the matters to be stated in the prospectus. So anyone who is engaged in or interested in the formation of a public company, they shall date and sign the prospectus setting out the information as is required by SEBI in consultation with central government. So accordingly, you need to have a declaration. So first report is the declaration that all the provisions of the act have been complied with. जो mention करना चाहिए था prospectus में वो सब हमने किया है, सब कुछ properly comply किया है. अ स्टेटमेंट, देखो दोनों वर्ड्स में फर्क है, एक डेक्लेरेशन है, एक स्टेटमेंट है, दैट नथिंग इज कॉन्ट्ररी टू द एक्ट, सेबी एंड सिक्योरिटीज कॉन्ट्रैक्ट रेगुलेशन एक्ट. So these are the reports to be issued. So if the company proposes to issue a prospectus, these are the reports that they have to comply with. तो दो या तीन ही points यहाँ पर actually important है. Next, read the fifth question. Let's proceed. Fifth question में one of the matters contained in the articles of 𝗧𝗵𝗲𝗿𝗀 Foundation incorporated as a limited company under section 8 was altered by passing a special resolution in the general meeting. Thereafter, the intimation of the same was given to ROC. सही किया क्या? If you want to alter the articles, then क्या करना है? Then the permission should be obtained before. Yes, अगर आपने ये आइडेंटिफाई कर लिया बहुत अच्छी बात है. इट्स अ वेरी फाइन माइनर पॉइंट जिसपे हम कभी ध्यान नहीं देते, उस पर क्वेश्चन आया है. सो इन दिस केस दे हैड इंटीमेटेड आफ्टर. ओके, बाद में इंटीमेट किया है, नहीं चलेगा. यू हैव टू इंटीमेट बिफोर. ओके, यू हैव टू ऑब्टेन द अप्रूवल बिफोर यू मेक द चेंज. तो देर इज एन इशू ओवर हियर. The articles was alteration was opposed by 𝗧𝗵𝗲 and company, a partnership, which says that alteration is not valid. You also have to decide whether 𝗧𝗵𝗲 can be a member in such company. It's a partnership firm. Can a partnership firm become a member in section 8 company? It's one of the privileges, no? वैसे partnership firm is not a separate person in the eyes of law. It is not capable of contracting. But one of the privileges of Section 8 company is that yes, it can be a member. So according to Section 8, the company shall not alter the memorandum or articles except with the previous approval. हमारे लिए कीवर्ड क्या है यहाँ पर? Previous approval. Previous मतलब आपको वो approval पहले लेना है, सिर्फ इंटीमेट नहीं करना है भाई हमने चेंज कर दिया. This power has been delegated to ROC. ठीक है, प्रीवियस अप्रूवल ऑफ सेंट्रल गवर्नमेंट था, लेकिन अब ROC से हम वो काम करवा सकते हैं. Firm can be a member of the Section 8 company. It's one of the privileges of Section 8 company. So here intimation was given, मतलब आपने after the alteration intimate किया है. What law requires is you to take the previous approval of ROC. So that is not done. Therefore contention of 𝗧𝗵𝗲 is valid. उसका जो objection है वो valid है. Section 8 allows a member, a firm to be a member of the company. So 𝗧𝗵𝗲 and company can be a member. यहाँ पर सबसे इंपॉर्टेंट पार्टनर स्टूडेंट्स ये है कि उन्होंने जो अप्रूवल है वो पहले नहीं बाद में इंटीमेट किया. अप्रूवल भी नहीं लिया तो इंटीमेट किया, वो इंपॉर्टेंट है. ये पार्ट आपको आना चाहिए क्योंकि वो जो फर्म वाला पार्ट है वो तो सबको याद होगा. ये एक छोटा सा प्रोविजन है, ध्यान रखना. देन वी विल प्रोसीड टू question 6. आपने नोटिस किया these are all very small questions. You know, only the first two questions were quite lengthy, but these are just small questions. Now Abhi is a chartered accountant by profession. He has been appointed as an executive director on the board. His job profile includes advising the board of directors on various compliance matters, strategies, business plans, risk matters relating to the company. Okay, keeping in view of the above position, can he be classified as a promoter? सोचो ना क्या आएगा इसमें. थिंक एंड देन आई विल डिस्कस. सोचो. पॉज द वीडियो, खुद सोचो, खुद अप्लाई करो कॉन्सेप्ट। एक तो वो चार्टर्ड अकाउंटेंट है, ओके, ही इज ऑल्सो एन MBA बाय प्रोफेशन। नाउ ही इज एडवाइजिंग द बोर्ड बट इन हिज प्रोफेशनल कैपेसिटी, नो, ये तो उसका काम है। इज ही अ प्रमोटर? नो। वॉट विल यू राइट ओवर हियर? बोलो क्या लिखोगे आप? वॉट विल यू राइट? यस, यू विल डिफाइन अ प्रमोटर। तो व्हाट इज द डेफिनेशन ऑफ प्रमोटर? सेक्शन नंबर इंपॉर्टेंट है यहाँ पर, सेक्शन 2 क्लॉज 69। Promoter means a company who is one, named in the prospectus as a promoter, identified by the company in the annual return कि ये हमारा promoter है. He has control over the affairs of the company either directly or indirectly as a shareholder, director, otherwise. According to whose advice, direction, instructions the board of directors is accustomed to act. ये सारे लोग promoters हैं. But this clause C will not apply to a person who is acting merely in the professional capacity like banker, lawyer, chartered accountant. ये तो उसका काम है। यहाँ पर जो अभी है उसके प्रोफाइल के हिसाब से he is advising the board but only in his professional capacity. He is not a promoter. If he exceeds his professional capacity, ये तो उसका काम नहीं है, and if he is exceeding that, then he may be considered as a promoter. But that is not given over here. You can also say, ma'am, it is an assumption. No, over here. Can we write it as an assumption? Yes, you can write that he is advising only in his professional capacity, considering the profile. Question 7. Question 7. Students, again, I repeat, you can download my annotated RTP document from the e-note section of my website, theorymasterslearning.com. Rich Limited created a charge on assets of the company on 2nd February. Whenever you have dates, always write what is happening on that date. Event or date, साथ में लिखना है. Charge is created on 2nd Feb. But the company has not registered the charge with ROC till 15th March. What procedure should the company follow to get the charge registered? Okay. Suppose the company realizes the mistake of not registering the charge on 27th May instead of 15th March, can it still register the charge? Advice. अब देखो relevant dates क्या है? Charge was created on 2nd Feb. Charge is not registered till 15th March. Company realized the mistake on 27th March. हमें देखना है कि delay है, कितना है, क्या fees भरनी पड़ेगी. So what I have written are only the facts. अब इसका सोल्यूशन क्या होगा? सोचो। चलो ये प्रोविजंस है ना, आपने किए होंगे चार्ज वाले चैप्टर में। क्या आएगा यहाँ पर बताओ? मैंने तो पूरी शीट भर दी है नोट से। ओके, टेल मी। If you don't remember these provisions, you can still pause the video, go through the provision in the module in your notes, whatever notes you are referring. देखो क्या आएगा इसका आंसर, फिर मेरे साथ डिस्कस करना. स्पून फीडिंग विल नॉट हेल्प यू गाइज. क्या लिखा है हमने यहाँ पर? देखो, if the charge is created on or after 2nd November 2018, then it must be registered within 30 days of creation. ठीक है? अभी देखो मैंने ना क्या किया है दोनों साइड में, आपको ये नोट बहुत पसंद आएगा. आई एम वेरी श्योर यू विल लव इट, क्योंकि इसके प्रोविजंस और एप्लीकेशन दोनों मैंने साइड में लिखे रही. स्क्रीन एडजस्ट नहीं हो रही. हाँ, अभी देखो मैंने दोनों प्रोविजन साइड बाय साइड लिखे हैं. देखो क्या आएगा यहाँ पर. Charge is created on or after 2nd November. ठीक है. It must be registered within 30 days of creation. तो मेरा चार्ज कब क्रिएट हुआ था? My charge was created on 2nd Feb 2001. 30 days means 2nd Feb है ना, remaining 26 days of Feb plus 4 days of March will give me 30 days. So the charge should be registered by 4th March 2021. What if the company fails? Then you can apply to the ROC for registering the charge within 60 days of creation. It means you get additional 30 days. Yes or no? So in this case, the company has another 30 days. So from 4th of March, you will count another 30 days. So remaining 27 days of March plus 3 days of April. So the charge should be registered by 3rd April. We did not register the charge even within 60 days of registration. Of creation. Further failure, ROC may allow the charge to be registered within the next 60 days by paying ad valorem fees. Okay, depending on the value, you have to pay the fees. Now, if the charge is created on 2nd Feb, you have time till 3rd April by paying just additional fees. If you still fail, plus 60 days, they may allow another 60 days for registration of charge on payment of ad valorem. Now that 60 days will be calculated from 3rd April because you get 60 days from that date. Earlier 60 days were from creation. Now it is 60 days from that due date. So 27 days remaining of April, 31 days of May, and 2 days of June. So you have time till 2nd of June. All right. So let's see what they have written over here. The company has not registered, it starts from here. Yes, the company should register within 30 days of creation. If not, you get another 30 days, that is 60 days from creation on payment of just additional fees. If you don't pay, then you get another 60. So here 4th March, they have shown the calculation. You can apply to the ROC, pay your additional fees. If you don't, you get another 60 days by paying ad valorem fees. So this 60 days, the company's 60 days expire on 2nd of June. Now they have realized on 27th May, they still have time. They still have time. First 60 days from creation have expired on 3rd April. Okay, not an issue. We still have another 60 days. Krish Limited can still get the charge registered within the next 60 days from 3rd April by paying ad valorem fees. The company is required to make an application for non-registration, giving sufficient reason for non-registration. Students, I think if you write these notes, you will quickly be able to revise during exam and you will also understand the concept. Okay, so you can download this sheet from the e-note section of my website. Okay, let's read the 8th question. Vishal has paid dividend consistently every year at the rate of 10% on equity shares for the last 5 years. Company has incurred loss in the current financial year. It still wants to declare dividend for the financial year 2021. Whether it can do so. Company has incurred loss. फिर भी dividend क्यों declare करना है? To maintain the goodwill, reputation, or positive market sentiment कि भाई इतने साल से देते आ रहे, अभी भी उन्होंने दिया ही है dividend. See, dividend can be paid either from the current profit और past profits of the company. दे तो सकते हो, लेकिन आपको याद है लिमिट्स थे उसमें, कंडीशंस थी. क्या था? एक काम करो, वीडियो पॉज करो, वो 3 पॉइंट्स लिखो. चलो याद करके लिखो. मैम याद ही नहीं है हमें तो. अरे कॉपी करके लिखो, लेकिन लिखो, याद हो जाए. तो वीडियो पॉज कर लो. चलो वीडियो पॉज करो, 2 मिनट ले लो. ट्राई टू रिकलेक्ट क्या थे वो प्रोविजन. अगर लॉस है फिर भी मुझे डिविडेंड डिक्लेयर करना है तो उसके क्या प्रोविजन थे, फिर मैं आपको बताऊंगी. चलो पॉज करके लिख लो. आई होप आपने लिखा होगा. yes, and was this your answer? The company can pay dividend either out of profits of the current year or out of profits of the previous financial years if there are inadequate profits या फिर है ही नहीं. What are the conditions to be satisfied? मैंने देखो यहाँ पर notes बनाए हैं. The rate of dividend should not exceed the average rate of the immediately preceding 3 financial years. तो आपका जो इस साल का डिविडेंड है, it should be less than the average of the last 3 years. But what if last 3 years में मैंने डिविडेंड ही नहीं दिया है? 3 साल, लास्ट 3 साल ईच लिखा है वहां पर, तो ये प्रोविजन अप्लाई नहीं होगा आपको. अमाउंट दैट यू हैव विदड्रॉन फ्रॉम द accumulated profit should be less than, it should not exceed 10% of the paid up capital and free reserves. और जो बैलेंस रह जाता है फंड में, आपके प्रॉफिट में, accumulated profits में, then that should be at least 15% of the paid up capital. जो भी अमाउंट आप विड्रॉ कर रहे हो, that should first be utilized for setting off the loss of the year in which the dividend is declared. सिर्फ थ्योरी है, एक्चुअली में इसमें कुछ एप्लीकेशन है ही नहीं, प्योर थ्योरी क्वेश्चन है. So if the company wants to pay dividend, it can do so if the conditions are satisfied. तो आपने ये कंडीशंस पढ़े होंगे डिविडेंड चैप्टर में. ऑल राइट, देन वी हैव क्वेश्चन 9. अभी अदर लॉस चालू हो जाता है. Surendra guarantees Virendra for the transactions done by Virendra and Jitendra during the month March 21. Okay, तो पहले parties identify कर लो. That is what I do. Surendra is surety, Virendra is creditor, Jitendra is debtor. Now I will proceed. Virendra supplied goods of 30,000 on 1st, 20,000 on 3rd to Jitendra. Then on 5th, Surendra died. Oh God, there are so many dates and events. 1st March, see how I have written. 1st March, goods 30,000. 3rd March, 20,000. 5th March, surety died. Arey, death! Section 131. Revocation, 130. Revocation by notice. Sorry, revocation by notice, 130. Died, 131. Immediately click hona chahiye. Then on 10th, being ignorant of the death, Virendra further supplied 40,000. On default, now Virendra sued the legal heir for 90,000. Decide whether the legal heir is liable for 90,000. And also there is one more question. Many a time students miss that क्योंकि नीचे लिखा हुआ है. What if the estate is worth only 45,000? 5 marks का question है ये. बोलो. सोचो. Yes, absolutely right. आपने ये बोला था क्या कि he is liable for the transactions before death. He is not liable, the surety is not liable for any transaction after his death. Legal representatives are not liable. Even if the creditor is ignorant, legal representative is not liable. And what if 45,000 ही मिले तो क्या होगा फिर? Liability of the legal representative या legal heir is limited only to the amount inherited. भाई हमारी personal liability थोड़ी ना है, फिर वो debtor देखेगा ना, उसकी primary liability वो देगा. Surety तो बस जितना दे सकते उतना ही देगा. So in this case we will apply section 131 students. अच्छा क्वेश्चन है, रिपीट क्वेश्चन है, ये पहले भी आ चुका है. According to section 131, in absence of the contract to contrary, continuing guarantee will be revoked automatically. 131 important for exam. But the revocation will be for future transaction. Surety will continue to be liable. Like in this case, the estate will be liable for the transactions before death. Estate will not be liable even if the creditor has no knowledge. So here in the first paragraph, they have written the theory, then facts of the case. After that, solution. In this case, he will be liable for the transactions before the date of death, that is 5th March. He is not liable for transaction on 10th, even though creditor was not aware of the death. Further, if the estate is worth only 45,000, legal heir is liable for that amount only. So, यहाँ पर भी ना ये भी conclusion में ही आएगा. I'll just mention that here also. ये भी conclusion है because 2 questions were asked ना. ये भी conclusion है. बहुत अच्छा लग रहा है, सिंपल सा एकदम. इट्स गोइंग वेल. इफ यू हैव रिवाइज्ड वेल तो हो जाएगा. स्टूडेंट्स, इफ यू वांट प्रैक्टिस ऑफ मोर क्वेश्चंस तो हमारा कंपाइलर जरूर देखना वेबसाइट पे, आपको बहुत पसंद आएगा. यू विल लव इट बिकॉज इट हैज ऑल द एग्जाम क्वेश्चंस, स्टडी मटेरियल, आरटीपी क्वेश्चंस, ये भी हमने इंक्लूड किया है वहां पर. एवरीथिंग इज अरेंज्ड यूनिट वाइज. लिंक दे दूंगी डिस्क्रिप्शन बॉक्स में, जाके जरूर देखना. अंजुम ड्रू अ चेक फॉर 20,000 पेएबल टू बबलू, delivered it to him. Bablu endorsed the check in favor of Reyansh but kept it in his table drawer. Oh. Subsequently, Bablu died and the check was found by Reyansh in Bablu's drawer. Reyansh filed a suit for recovery of the check. Whether Reyansh can recover the check under the provisions of the Negotiable Instruments Act. क्या करें? सोचो. Think. I'm giving you time to think, to apply the concepts. Wrong to wrong. Try करो. If you are thinking something about delivery is not complete, it is not negotiated, absolutely सही track पे जा रहे हो, correct है वो. सोचो. What is negotiation? Negotiation means transferable by delivery. You are transferring the benefits, the rights by delivery. Delivery is important. Negotiable instrument जब हम पढ़ते हैं, the word negotiable means transferable by delivery. And the word instrument, it means any document carrying certain rights and duties. Even if it is a bearer or an order instrument, there is delivery. See, in case of bearer instrument, how will you negotiate? Mere delivery. Order instrument, endorsement and delivery. Delivery is compulsory, no? I drew a check, kept it in my table drawer. कैन द पेई से, कैन द एंडोर्सी से, ये तो मेरा चेक है. नेगोशिएशन हुआ ही नहीं. Negotiation is complete only upon delivery. So that is one thing which you need to write, that negotiable instrument में negotiation is complete only upon delivery. Here, delivery is essential not only at the time of negotiation but also at the time of making or drawing the instrument. मैंने चेक ड्रॉ किया, आपको दिया, आपने आगे एंडोर्स किया, नेगोशिएट किया, बट पहली बार तो दिया ना आपको. The rights are not transferred unless it has been delivered. If person making the endorsement, but before the same could be delivered, dies, legal representative cannot negotiate the same by mere delivery. तो endorsement हो गई, okay, endorsement हो गई, delivery नहीं हुई, तो नहीं, benefit is not transferred. In the given case, Reyansh is not liable to pay because there was no delivery. Easy. Okay, but फटाफट हो रहे हैं ना questions. खुद सॉल्व करो स्टूडेंट्स. मैं बार बार बोलती जा रही हूँ बिकॉज हमारी ना आदत छूट गई है. वी आर वेरी फॉन्ड ऑफ स्पून फीडिंग. नहीं, मत करो वो. आई वॉन्ट यू टू स्टडी एंड सॉल्व द क्वेश्चंस ऑन योर ओन. यू शुड बी एबल टू सॉल्व दिस ऑन योर ओन. आयुष एंड विपुल, अ वेरी नाइस क्वेश्चन है. मुझे इसकी फ्रेमिंग बहुत अच्छी लगी. आयुष एंड विपुल, दे आर गुड फ्रेंड्स pursuing CA course. While doing group studies for the paper Corporate and Other Laws, they are confused about the provisions of Section 3 of the Companies Act. Section 3 provides that a company may be formed for lawful purpose by may, may लिखा है इधर, may. Both are in difficulty about the meaning of the word may. Is it mandatory or directory? उनको क्या लग रहा है? A company may be formed for lawful, मतलब unlawful के लिए भी फॉर्म कर सकते हैं क्या? अभी मुश्किल ये है कि मे को यहाँ पर मे जैसा ही समझे, ऑप्शनल डिस्क्रिशनरी, या फिर इसको मैंडेटरी के जैसा समझे, शाल. क्या होना चाहिए यहाँ पे? मैंने हिंट तो दे दिया आपको. आई गिव यू अ हिंट. शुड आई कंसिडर मे एज मे ओनली? अगर वैसा होता तो कंफ्यूजन ही नहीं होती ना. बोलो जनरल क्लॉज एक्ट में आते ही नहीं. क्या करेंगे इधर? सी, मे वर्ड जो है वो जनरली तो डिस्क्रिशनरी है. इट्स लाइक इट शोज ऑप्शंस. इट इज नॉट मैंडेटरी. बट वर्ड शाल, दैट शोज दैट इट इज मैंडेटरी. द वर्ड शाल raises a presumption that it is mandatory. It is imperative, मतलब वो तो करना ही है, वो तो फॉलो करना ही है. But the word may, it is not mandatory, it's just discretionary, optional. But sometimes may has a mandatory force. Because अगर हमने उसको as discretionary ले लिया, it will defeat the provisions of act. मतलब, like in the given example, if we read the sentence with the word may, देखो मैंने लिखा है उधर, I have written it, see? What is the meaning of that sentence given in the answer? If I use the word may, I read it as it is absurd. कुछ अजीब मीनिंग आ रहा है. तो अगर मैंने एक्ट में मे वर्ड जो दिया है उसको एज मे ही अप्लाई किया तो यार ये तो गड़बड़ लग रही है. आई डोंट थिंक द लॉ मेकर हैड दिस इन हिज माइंड. आई डोंट थिंक ये उसका बोलना होगा. तो एक काम करो ना, मे को शाल के जैसे पढ़ के देखो तो. Why don't you read may as shall? Does it make sense now? Yes, it does. Then law says you will have to interpret may as shall in this case. So step 1, they have written the theory only. Step 2, then they have come to the solution. Okay. So may will sometimes be considered as shall. Dekho, whenever there is confusion, only then you will go to the general clauses or interpretation of statutes. So here they are confused whether the word may should be read as it is. I don't think that was intention of the lawmaker. In the given case, may should be taken as mandatory. No. You will form the company only for lawful purpose. So even though they have used the word may, you have to read, you have to interpret that as shall, compulsory. You can form only for lawful purpose, not unlawful. Very nice question. बहुत ही अच्छी तरह से फ्रेम किया था क्वेश्चन. And it is simple if you know what is to be written. So I think this is a good practice for us. Last question, students. Last question. Oh, where am I going? When can preamble be used as an aid of interpretation? Students who are studying from the module, you will face a lot of difficulty because module language इतनी confusing है. मैंने उसको simplify कर दिया. कैसे? देखो. What is the meaning of preamble? Preamble defines the scope, the objects of the act. If you are confused कि भाई मैं जो काम कर रही हूँ वो ये act में covered है क्या? Refer the act. Students, see the color coding that I have used. Please see the color coding. ये उनका आंसर है. If you read, you will be totally confused. So what I have done, the points which I have marked in blue, they explain the meaning of preamble, which you should write together. ऐसा mix करके नहीं लिखना चाहिए. अभी देखो, सबसे पहले explain the preamble. What is preamble? All the blue points are written. देखो, aim and object, scope of the act. It is a key to the mind of the lawmaker. लॉ मेकर ने क्या सोच के ये एक्ट बनाया होगा, इसका स्कोप क्या है, इसका ऑब्जेक्ट क्या है, क्या होगा उसके माइंड में. इट इज अ ब्रीफ समरी ऑफ द लेजिस्लेटिव ऑब्जेक्टिव बिहाइंड द एक्ट. आई वांट टू नो कि मेरा जो इंस्ट्रूमेंट है वो नेगोशिएबल है या नहीं है, वो एक्ट में कवर्ड है कि नहीं. प्रियम्बल देखो ना, प्रियम्बल में ऑब्जेक्ट स्कोप में क्या लिखा है, ओनली बिल ऑफ एक्सचेंज, प्रॉमिसरी नोट, चेक. इन 3 इंस्ट्रूमेंट को ही नेगोशिएबल इंस्ट्रूमेंट एक्ट अप्लाई करेगा. तो स्कोप से मुझे पता लगेगा वेदर द इंस्ट्रूमेंट दैट आई एम थिंकिंग इज कवर्ड अंडर द एक्ट और नॉट. इट हेल्प्स इन द केस ऑफ एम्बिग्विटी, कंफ्यूजन इन लॉ. ठीक है, तो ये सारे ब्लू मेरे पॉइंट्स थे. मीनिंग क्या है? प्रियम्बल कैनॉट और डज नॉट, इट कैनॉट कंट्रोल, क्वालिफाई द लैंग्वेज ऑफ द एक्ट. सपोज प्रियम्बल में कुछ लिखा है, प्रोविजंस में कुछ और ही लिखा है, प्रोविजंस विल अप्लाई, प्रियम्बल फिलहाल इग्नोर करो. It cannot override the provisions of the act. You cannot tell है provision साइड में रख, ऑब्जेक्ट क्या है मैंने बनाया है. Conflict between preamble and provisions will prevail. If the language is clear, there is no need to refer preamble. Ambiguity होगी तो भी जाएंगे ना. कितना clearly मैंने उसको देखो separate कर दिया है. तो आप भी ऐसे ही करना. You will write the meaning separately and then it does not or cannot. In the module, in this model answer, they have mixed everything. Blue color is explaining the meaning, orange is explaining that it cannot or does not. Now when can they use it as an aid to construction? Actual answer तो अब आया है, वो तो सब टाइम पास ही चल रहा था. Actual answer क्या है? When there is ambiguity, we will refer the preamble. People are arguing that their instrument is covered by the Negotiable Instrument Act. Go refer preamble ना, क्या लिखा है. If the words are clear, then we need not resort to preamble. If the words are confusing, then yes. If they are too general, where the words appear to be too general or the application is ambiguous, then you will refer the preamble to define the scope or the application for which the words are meant. It means if there is ambiguity, then refer the preamble. Otherwise, if the provisions are clear, काम उधर ही खत्म हो गया ना. So students, you need not copy this now because I have uploaded this in the e-note section of my website theorymasterslearning.com. वहाँ पे जाके ये download कर लेना. It will save a lot of time. And with this, my dear students, we have completed the discussion of RTP for May 22. It was very interesting. I really enjoyed all the questions क्योंकि बहुत अच्छे questions इस बार ICAI ने चूज करके डाले हैं. एंड दीज आर ऑल्सो देयर इन माई CA लॉ कंपाइलर. तो बस आज के लिए इतना ही, काफ़ी लंबा हो गया. अभी आप भी थक गए होगे, मैं भी थक गई. चलो, आई विल टेक योर लीव, बट बिफोर दैट डोंट फॉरगेट टू लाइक दिस वीडियो, शेयर इट विद योर फ्रेंड्स एंड सब्सक्राइब बिकॉज वी आर coming up with revision lectures for my CA Inter students appearing in the May 22 exam. So stay tuned.